Hello and welcome to Red Thread. Today we're going to take a look at the U.S. tariff policies that have generated a lot of attention around the globe over the last year and look to continue to do so as 2026 unfolds. The biggest issue right now is we're awaiting a U.S. Supreme Court ruling on the use of the law that the Trump administration opted to tap in order to put these tariffs in place. It's called the International Emergency Economic Powers Act, or IEPA, or IEPA, a law from 1977. The administration interpreted this law as allowing them to impose tariffs on imports coming into the U.S. from around the globe to address what they said is an emergency situation relative to the trade picture. Now, what this has done is to, of course, cause a lot of angst and anxiety around the globe. We did see countries start to send imports or send exports into the United States a little more aggressively in the first half of 2025 as they sought to get ahead of the tariffs being imposed in the U.S. Since then, we have seen some changes in the level of imports coming into the United States. But at issue right now is this Supreme Court ruling, as there's been a legal challenge mounted to the U.S. use of the IEPA to impose the tariffs. This decision awaited by the U.S. Supreme Court could have several potential impacts. First, the ruling itself will be critical. Will it be a full affirmation of the Trump administration's authority to use the IEPA to levy tariffs? Will it put significant limitations on the IEPA use, or will it rule it out completely? And there could also be a potentially mixed ruling from the U.S. top court that could force a recalibration of U.S. tariff policies. Now, the timeline for when this administration ruling or when this Supreme Court ruling is coming is far from clear. It could come anywhere from now between the end of June, which is when the current U.S. Supreme Court term will come to an end. Now, should the court rule against the use of IEPA, there are still going to be tariffs in place. Here's why. The Trump administration has made clear if they're not able to use IEPA to impose tariffs, they will turn to other routes. One being Section 301 of the U.S. Trade Act of 1974. This is one that probably a lot of trading partners are familiar with and companies here in the United States. This puts the potential in place for tariffs to be put in place if a country or if a product coming into the U.S. is potentially injuring a U.S. firm or a U.S. economic sector. But this involves putting out a formal investigation, providing notice via what's called our Federal Register, holding hearings, and taking in public comment. Another route is Section 232. This approaches tariffs from the perspective of national security grounds. This is what the U.S. has used to put the steel and aluminum tariffs in place. Also, there's Section 201 safeguards, which would route the process through the U.S. International Trade Commission, but there'd also have to be a finding of serious injury to a U.S. industry that can have a lofty legal threshold and can have some political sensibility or sensitivities as well. There's also possibly Section 338 of the Tariff Act of 1930 that allows for retaliation in the event of discriminatory treatment. But that again is far from assured. But the bottom line remains that there will be tariffs once the Supreme Court rules, whether it's via IEPA or via some other route the administration has made clear. But the other key to remember as you look at this situation is, while global trade data may not reflect a great deal of activity that has been altered by the tariffs, it has created changes in trade flows around the globe as products that are no longer coming into the United States have to find a home somewhere. That's why overall trade levels may not vary a great deal according to global trade data, but trade flows within certain countries and around the globe will have been altered by the U.S. tariffs.